So, what are presumptions in California legislation? There are a handful of bills every year in the California state legislature that create a so called presumption in state statute. What are these presumptions? Well, basically, a presumption in law is a conclusion that's drawn based upon specified facts until that fact has been rebutted. With a presumption, a party doesn't have to actually prove the fact that's being presumed. Instead, the burden shifts to the other party to actually disprove or rebut that fact. There can also be different standards required for rebutting or disproving that presumption. So I wanted to walk through a couple of examples that have been drawn from recent legislation that you might have seen amongst California bills in the 2022 California legislative session. Now, when I read these four examples, note the two different standards of evidence that's used in the first example and the third example. So here's the first example. This subdivision creates a presumption affecting the burden of producing evidence and may be rebutted by clear and convincing evidence showing and then specifying. The second example is that this presumption is disputable and may be controverted by other evidence, but unless so controverted, the blank is bound to find in accordance with it, the court or the agency, for example. Here's the third example. This presumption may only be rebutted by a preponderance of the evidence. To overcome the presumption set forth, the court shall find that, and then you specify it. And the fourth example is notwithstanding any other law, there shall be a presumption that the disclosure of information relating to a covered action shall not, and then it's specified what it shall not. Now, presumptions are mostly found in civil related statutes. However, presumptions can also be used in the criminal context in California's penal code. So here's an example. Blank creates a presumption of insufficient mens rea or mental state to accomplish the particular criminal offense. On the other hand, a presumption can be prohibited from being used in the criminal context as well. I came across a bill with this statement. This presumption is a presumption affecting the burden of proof, but it does not apply in a criminal action. In some of our state statutes, in those 29 codes, the legislature determines what type of evidence is or is not sufficient to overcome a particular presumption. So, for example, you might see language as we did in the 2022 session that said, a written declaration or testimony from a witness is not sufficient to rebut the presumption of liability of the respective parties. Now, what happens when the other party rebuts the presumption? That can be addressed in statute or it doesn't have to be. So the following is an example of what a court is required to do per the statute. If a court finds the presumption is rebutted, it shall provide its reasons on the record. So in all of these examples I've talked through, there's a particular reason why the legislature has chosen to create this statutory legal presumption in law. The presumption benefits one party and places a greater burden on the other party to overcome that presumption. In some of our state statutes, the legislature has designated the standard of evidence that the party attempting to overcome the presumption is required to meet. And as you've heard, these presumptions can be used in both the civil as well as the criminal or penal code laws as well.